Lawyers of Reddit, what's your best most badass I rest my case moment? Complaining witness accused my client of harassment stalking. Said she told him numerous times that she wanted nothing to do with him. My client claimed they were dating, but whenever she got mad at him, she'd call the police and say he was harassing her. On the stand, she testified that she'd never dated him, never invited him into her home, wanted nothing to do with him. She presented a photo on her phone of him sitting on her porch to prove that he had come to her property. I asked the judge permission to look at the photos before and after the porch photo for context. Girl had dozens of photos of the guy, who was clearly her boyfriend. I showed her one such picture. This is Mr. So-and-so, right? Yes. In this photo, he's on a bed. Yes. The bed is yours. Yes. The bed is in your bedroom. Yes. You took this photo of him. Yes. He's smiling in the photo. Yes. And in this photo, he's wearing your brassiere. Yes. No further questions, Your Honor. That's really sad. I'm glad she got in trouble for this. Really takes advantage of a situation no one should have to deal with. I was prosecuting some kid. He had an antisocial behavior order, which meant that he was not supposed to go to a certain street. He had pleaded not guilty on the basis that he had not been there. I opened my cross-examination by holding up a map and pointing at the street. I said to him, "You went here, didn't you?" He said yes. In England, we don't say I rest my case. Instead I looked up at the bench, said no further questions, and sat down. It might not seem bad but I got the defendant to admit the offense with one question. That never happens. Defendant in a bench trial for a speeding ticket said he couldn't possibly go as fast as the officer clocked him. He knew this because he videotaped himself accelerating from a full stop to the location of where the officer sat. His experiment showed his vehicle could only get to 55 miles per hour and not the 67 mile per hour he was clocked at. The aider then moved to have another speeding ticket issued because the actual posted speed limit was 50 miles per hour. 5 miles per hour over is probably just a fine and a few points. 17 over is possibly reckless driving depending on the officer's discretion. I'd take that. IP lawyer. Deep in a set of terms and conditions on a website, our client's details, name and contact details, were listed. So it is very evident that they just copy-pasted our client's legal terms and conditions and missed a couple of details they needed to change. I was handed the matter, did a quick Ctrl+F for client details, and it was an open and shut case. Not really that impressive, but saved me hours of time going through each term one after the other, noting exact similarities for a letter of demand. Welcome to the world of law, where we spend millions on technology but people don't know how to Ctrl+F or use a simple spreadsheet. It wasn't at trial, though we had one of those and I won it easily. Just always stuck with me because of how clearly the law supported my position to the point that it was inarguable otherwise, and also because of how ridiculous the claim of monetary damages was. Guy moved out of his apartment, turned in his keys, then came back 15 days later demanding access so that he could retrieve belongings that he had left behind, which at that point had been trashed. It was just some minor furniture type items. Lampshade is the only thing I clearly remember, and a box of his college notebooks. That is, notes he took during class. He is furious and sues the landlord in small claims for $5,000, state maximum. Because his notebooks have such huge value apparently, they hire me and I respond, which moves the case out of small claims. It's just the way it works here. After time in a legal advice, I know this is not the case for every state, but our rule is better than yours. But enough aside, this puts him at a huge disadvantage because now he can't rely on the lax rules of small claims, so he goes out and hires a lawyer. The lawyer calls me to try to talk settlement. I know her pretty well, so I wasn't rude or anything, but I kind of scoffed and was like, no, that won't be happening, and direct her attention to a particular state statute, then read it out loud to her. This statute, unlike everything else in the law, isn't overly long or wordy or hard to follow. It just says bluntly that when someone actually moves out and gives notice of this, items left after 10 days are abandoned. Period. End of story. I could feel her deflate on the phone and encourage her to dismiss the suit. She did not. We proceeded to a short bench trial in district court that we won. terrible people had stolen all of this little old lady's money. They said it was a gift, but their only evidence was a document in the bad person's handwriting that was allegedly dictated. It said September 2012. No day, just the month. Clearly the rogue had forged that when she found out about the lawsuit and, not remembering when she had stolen it, she hoped if she could guess within the month no one could challenge her. So I'm questioning her about it. Exhibit B is the little old lady's bank record. Now that withdrawal at the bottom, is that the alleged gift? Yes. Can you read the date of that transaction for me? The 25th of August, 2012. Thank you. This is the most satisfying of the lot. Cheers. Pro bono case. Representing woman who was trying to get a permanent protective order against her boyfriend. I ask her if he has contacted her since the temporary order was issued, which is a crime. She says yes. He called her 3 times. Defendant, objection your honor. Judge, state the grounds for your objection please. D, the facts. I only called her once. Me. Closes file and sits down. Obligatory, not a lawyer, but I was defending myself against a debt collector for a debt so old I could not even remember for sure that it was mine. Me to the debt collector, can you provide the actual contract bearing my signature along with a chain of title to the debt? Debt collector's lawyer, crickets. I look at the judge. Judge to lawyer, well can you? Debt collector's lawyer while looking through paperwork, well, no, not at this time your honor. Judge, case dismissed. Note, to prove that a debt collector owns your debt, they must prove how it came to own it. Often, old debts are sold and resold over and over again to a number of subsequent debt buyers. When this happens, the debt collector must prove each and every assignment by showing a chain of title reaching all the way back in history to the original creditor. More often than not, for old debts, it is impossible for the collector to show this. They really need to reform debt so that this chain of title is required before collections can proceed. It should be a very simple thing to do and it would prevent abusive practices. This isn't my story, although I am an attorney, it's my dad's. He was a federal prosecutor, and a few years ago he prosecuted a high-profile white-collar fraud case against a defendant that had essentially run a Ponzi scheme through a small investment bank in Ohio he had purchased. The fraud resulted in $200 million stolen from low to middle class victims that had invested their retirement savings. The defendant, who was also an attorney, testified that he never did anything illegal, and the investment bank simply failed because of the downturn in 2008, which resulted in failed investments. My dad then played for the jury a recording from a wiretap the FBI had obtained of the defendant's cell phone in 2009. The call was a conversation between the defendant and his CFO. During the call, the defendant instructed the CFO to lie to investors by telling them the bank's computer system was down for a Jewish holiday so the investors couldn't withdraw their money. The CFO responded, "Can't we go to jail for this?" The defendant answered, "Yeah, but no one is going to find out." The defendant was convicted on 12/12 counts. During sentencing, my father quoted Dante's Inferno, citing the fact that the bottom level of heck is reserved for grifters and fraudsters who know better but still take advantage of people. The defendant was sentenced to multiple life terms. I represented a poor woman whose husband left her and their child behind. He was of course unemployed. He did not want to pay and started his plea with how much he loved his child but couldn't afford anything. I started to laugh, which was of course a bad move of me. The guy, his lawyer and the judge stated that it was unprofessional for me to laugh. I luckily came back, presented his rental bill, petrol bill and phone bill, together forming 2 times his welfare check without his daily bar tab. So we can only conclude he has a job in black, and that he chooses not to pay for his beloved child. The judge looked at him, he couldn't reply, and we finally won with him needing to pay 1.5 times his welfare check to his ex-wife. Sadly, he fled to North Africa to escape the sentencing. In the state of New York, if you are issued a citation for a traffic violation, you are allowed to request a supporting deposition, which is essentially the officer swearing that he saw you violating whatever law you broke. The courts must supply this SD within 30 days of your request, or you can motion to dismiss the case. On traffic violations where the SD isn't supplied by the officer at the time of the citation, there's a box you can fill in where you can request one. I filled mine in with black pen and went down to the courthouse. I handed the citation to the clerk and asked for a reschedule of my court date to more than 30 days out because I was going out of town. No SD was supplied to me. I showed up and motioned to dismiss and the judge was legit proud of me. His words were, "I'd never look down on someone for successfully navigating the legal system." Dismissed. I once had an appeal where the precedent, all from other circuit courts, was very bad for me. The circuit court I was arguing in front of had a decision that was very good for me, but it wasn't published, meaning that it was not precedential. My goal was to convince the court to follow its unpublished decision, not the decisions of the other circuits. During my argument I cited the unpublished decision. One of the judges interrupts me and asks, "But wasn't that decision unpublished?" I answered yes, but it was well reasoned. He replied with a self-effacing quip, "I was on the panel for that decision, so it couldn't have been that well reasoned." The audience laughed a bit. I answered quickly, "In that case, Your Honor, it was at least well written." The audience and all the judges burst into laughter. I ended up winning in a published decision, which turned the old unpublished decision into binding precedent. A bit of humor can go a long way in the courtroom, especially when you're flattering the judges. Once had fairly standard RTC case. My client going round a roundabout in a small car got sideswiped by a lorry driver. Claim for damages, loss of earnings and the rest. Other side's entire case rested on whether the lorry driver saw my client or not, as we could prove from CCTV that my client was well within her lane, within speed limits and generally on solid ground legally speaking. Their client gets into the witness box and is asked if he saw my client. While you can't ask leading questions to your own client, a napkin could tell he was being prodded towards saying no. The man promptly responds, I did, but the bee shouldn't have been where she was." My cross-examination consisted of getting him to repeat that answer and then sitting down. To date, the easiest day in court I ever had. I helped the prosecution rest his case. LOL. I got jammed up during spring break doing dumb spring break crap, so there I was in court to face the music, misdemeanors. As I sat there waiting for my turn, I watched person after person go before the judge. The prosecutor read their charges and some information from the police report, stating what the potential max sentence was for each all. I don't remember exactly. Then the judge asked what plea they wanted to enter. Almost everyone said not guilty, and I could see that both the judge and prosecutor were getting tired of their bulls. Finally, my turn came. I was probably second to last after what seemed like hours, but may not have been. The prosecutor read off my charges and cited the police report. The judge looked at me with this "let's just get it out of the way, tell us you're not guilty" look and asked how I pled. "Guilty, Your Honor." The judge and the prosecutor both looked at each other and the judge said, "Kid you not, say again or beg your pardon." "Guilty, Your Honor. I did it, just the way officer so and so's report reads." They exchanged looks again and the prosecutor held his papers at arm's length as if to get a better look at them and did the unthinkable. "Your Honor, this all reads to me like a case of college prank gone bad. The county moves to reduce charges to Ziz." I walked in there expecting some jail time and walked out paying like $110 plus costs. I didn't really know how to feel about the scariest day of my life turning into one of the happiest ones. Same thing happened to my dad. Got a traffic ticket for something. Had to go to court. Everybody else is doing the waterworks. Dad's turn is up. Judge asked him about the ticket. Dad just says that yes, he did it. He didn't mean to, but he did. Judge just told him to get out of there, or something like that. LOL. I've had a couple such enjoyable moments, though they have all been no further questions moments. As I rest my case is not something I get to say in family court. I apologize in advance for what is likely to be a pretty lengthy post. In the first ever domestic violence restraining order, DVRO, case I had as a new attorney, I represented a woman who has broken up with her ex-boyfriend after he has hit her. She filed for a DVRO when he continued to harass her and show up uninvited to her place. The process for getting a DVRO, at least in my state, is the victim files documents describing the alleged abuse, and a judge decides to grant a temporary restraining order, with a hearing scheduled within a couple weeks, where each side can present their case. Even after my client got the temporary restraining order, Her ex continued to try to contact her, including randomly showing up where always she took her dog for a walk at 5 a.m. the morning of the hearing, even though this was 25 miles away from where he lived. At the hearing, even before either party got to testify, the judge reiterated that any violation of the temporary restraining order, including attempted contact with the victim, was grounds for a permanent DVRO being issued. The judge ended up ordering a brief recess before we were to introduce evidence testimony. During the recess, my client went to the bathroom, and the ex decided it would be a good idea to follow her into the bathroom to talk her out of pursuing the DVRO. He had not noticed that the bailiff was also using said bathroom, and the bailiff immediately ordered him out of the women's bathroom and threatened to arrest him. When we got back into the courtroom, X took the witness stand to testify. I asked him if he had just attempted to enter the women's restroom to make contact with my client. When he answered affirmatively, I smugly stated that I had no further questions. The judge tore him a new one, and the DVRO was immediately ordered. On one other DVRO case I handled, I was defending a husband who was accused of completely unsubstantiated and clearly fabricated abuse by his train wreck of a wife. My first question for the wife when she took the witness stand was, isn't it true you made these allegations and are requesting this DVRO solely for purposes of gaining an advantage in custody and support proceeding? I obviously assumed she was going to deny it and was really just planning to try to get her angry on the stand so she'd slip up and give inconsistent or conflicting testimony. When she answered yes, the judge looked as surprised as I was. I immediately stated that I had no further questions, despite the fact that I had prepared at least 40-50 questions for her, and sat down. The judge tossed the case moments later. Two high school kids spend their day pee each other off, so they decide to drive to a fast food restaurant to fight. They park, get out, immediately approach, and swing. Kid A connects the first blow squarely in solidity across Kid B and instantly drops him. The whole fight was one punch with a total elapsed time of a few seconds. The restaurant is sued for failure to protect its patrons. The case is weak. Unfortunately, Kid B hit the pavement hard and had severe brain damage. Attempts were made to settle, but they were after millions. We knew walking in they had two former employees testifying about large crowds building up after school. The plaintiff attorney aimed to prove the restaurant had a reasonable expectation of trouble and should have had armed guards in the parking lot. At best, their witnesses wildly exaggerating to the point of perjury. Their credibility was shaky and being highly disgruntled for being fired. We had a list of witnesses ready to refute their claims. At trial, the plaintiff attorney presented first. He spent a long time building up the bad blood between the kids, the serious damages of Kid B, and his potential earning capacity. A lot of foundation work to build sympathy for his client. We break for lunch on day 2, after which it would be the defense presentation. As we were talking through where we were and how we should proceed, we realized the restaurant was not really mentioned at all. Plaintiff held back his star witnesses to rebut the defense presentation. The restaurant was safe. So when we reconvened, defense rests, Your Honor. The plaintiff attorney fell out of his chair. He begins frantically shuffling papers on his table and was stammering. The judge says, I take it you will need a few minutes for your close. After that break, plaintiff's attorney gave one of the worst closing remarks I've ever heard. Jury, Kid B 10% at fault. Kid A 90% at fault. Restaurant 0%. Oh man, I think this is my favorite one. You just let the other attorney hang himself and his client all on his own. That is just fabulous. I was in a gang-related jury trial for attempted murder. Defendant was a known crip and the victim was a blood. Against his attorney's advice, the defendant testified. Defendant had a tattoo on his arm that said BK. I asked him what BK meant and he replied with blood color. I was shocked he said what it actually meant, but in retrospect, I guess I shouldn't have been since he actually decided to testify. Burger King. So I typically do plaintiff's work for corporations, but one of my clients was getting sued by a former contractor for work allegedly performed right before he was fired in the amount of $150K. I had never dealt with opposing counsel. She was about my age, 32, and seemed nice heading up to trial. The day of our pre-trial, just 5 days before trial, she tells me in the elevator, I hope you know I'm going to kick your butt in trial. I laughed and she said, no really, you are screwed. Trial comes and she drags out her case over 5 days, and I start to get the impression her client made up the invoices with her help. She finally rests her case and I called her client as my only witness. He immediately testified his attorney showed him how to make the invoices. The judge wouldn't allow them into evidence. She lost her case and was sanctioned $5K for falsifying evidence. She appealed and the Court of Appeals ripped into her. Needless to say, I didn't get my butt kicked. I've always heard that if you're going to break the law, you shouldn't draw excess attention to yourself when you do. A lawyer friend of mine had this scenario. His client moved into a newly built office building, where they got to do a fair amount of construction work to arrange the offices on their floor how they wanted. As it turned out, there was this overly large gap between the lip of the elevator door and the floor, on the order of an inch or so. You wouldn't think that's enough for an issue, but it was leading to people continuously tripping themselves up. So, since they were doing construction anyway, they paid someone else to do a small concrete pour to smooth things out and fix the problem. The original construction company finds out about this and uses their technically unconcluded contract to insist that they can rip up that floor and fix it themselves. They do so, and now instead of a small issue next to the elevator, the entire surface of the elevator lobby on that floor is ruined. Random and half-inch dips and hills all over the place. There was basically no leveling of any kind done. Upon being told that this was unacceptable, the construction company responded by sending the client a bill for the first redo that they hadn't wanted done since they'd solved the problem, and a quote for fixing it. The timeline of these events was presented to the court, and then an extremely scientific presentation on just how truly horrid this floor was with high-resolution topographic maps of the surface presented, clearly showing just how bad this floor was. And then the lawyer, while talking with the lead engineer for the construction company, leans in and asks the question, is this acceptable work for your company? The reason this is such a mic drop is that it is handing the construction company a win, but at great cost. If they say yes, then the client has to pay the first bill, and would have to pay for a redo, but then the lead engineer of that construction company goes on public record as stating that shoddy work is considered acceptable by the company. If they say number, then the construction company eats the cost of the redo and the redo necessary to fix it, and goes on record as saying they screwed up. But I was in traffic court one time and saw a lawyer straight up murder a cop with words. The cop had previously testified that the weather on the night of the traffic stop was heavy rain and wind so strong that the defendant could only open his window 3 inches, and that the car had stopped on an area with very little shoulder, forcing the cop to approach from the passenger side, not the driver's side. The cop had then testified that he smelled a strong smell of alcohol on the defendant's breath. When the defense lawyer got up, he repeated what the cop had said almost verbatim and asked how he could have possibly smelled alcohol on the breath of someone on the other side of the car, through a 3 inches crack in the window, on a night with pouring rain and strong winds. The cop sort of opened and shut his mouth a few times, squirmed around in his seat, and said, "That's just what I always write in my log, to remind me that it was a DUI stop." The judge threw the case out. No motion to dismiss needed. Then he took a break and called the traffic prosecutor and the cop into his office. I'm guessing it wasn't for a nice spot of tea and some scones. Really, people? You've never seen Ianl in a comment thread before? How about writing DUI stop in the book? Much shorter. Good god, man. This isn't an I rest my case moment, but it was a dang fun cross-examination. I was defending an alimony case, and in my state cohabitation with a new lover is a bar to alimony. We had had a pie on the plaintiff's tail for a few months and she and opposing counsel had no clue. I had a mountain of evidence that the plaintiff had moved in a new boyfriend and they were essentially husband and wife without the marriage certificate. So, if I could prove cohabitation, she didn't get alimony. On cross-examination, I'd set her up with a question I knew she'd lie about and then hit her with a photo contradicting her. So it's your testimony that John Doe never visited your house. Oh. So do you have an explanation for why he's walking in your front door in this photo? So he did come over, but never stayed overnight, I see. Do you have an explanation for why his car was parked outside of your overnight on X and X nights are seen in these photographs? For a solid 45 minutes to an hour I'd ask a question, she'd lie, and then I'd impeach her with a photo directly contradicting her. I was catching her in a lie per minute or more. She never wised up, either. After the first few times you'd think she'd tell the truth knowing that I'd just catch her in another lie, but nope. She just kept on lying. Again, it wasn't the flashiest or even an I rest my case type moment, but it's the most fun I've ever had on cross. In the subsequent order, the court made the specific finding that the plaintiff's testimony was without an iota of credibility. If you are new to the channel, you can subscribe. I publish new videos every day. Until then, check another video. Bye for now.